Hello everyone, I'm Aratrika Bhaumik and I welcome you all to another episode of Courts Today on Live Law, where we update you about all the important legal developments that took place across the country today. We will begin with developments from the Supreme Court and then cover High Courts and other subordinate courts. If you like our content, please do not forget to like and subscribe to our YouTube channel. Let's begin. On the 8th day of the hearing in the hijab case, the Supreme Court Judge Justice Sudhanshu Dhulia orally remarked that the Karnataka High Court should not have gone into the question of essential religious practice. Justice Dhulia also commented that the High Court had relied upon a term paper of a student in the judgment. High Court should not have gone into it, that is the essential religious practice. They have relied on a term paper of a student and they have not gone to the original text. Other side is giving another commentary. Who will decide which commentary is right? Justice Dhulia orally remarked during the hearing today. The Supreme Court Constitution Bench, comprising Chief Justice of India UU Lalit, Justices Dinesh Maheshwari, S. Ravinder Bhatt, Bela M. Trivedi and J.B. Pardewala today continued hearing on the cases challenging the constitutional validity of reservation for economically weaker sections. The petitioners concluded their arguments in today's proceedings. Meanwhile, the Attorney General for India, K.K. Venugopal, appearing on behalf of the Union government, commenced his arguments and stated that the SCs and STs had been loaded with benefits by way of affirmative actions. He added that these groups were highly unequal and in tremendous position so far as reservations were concerned. A constitution bench of the Supreme Court today agreed to consider whether the practice of excommunication prevalent in the Dawoodi Bohra community is a protected right under the Constitution of India. A 5-judge bench of the Supreme Court, comprising Justices S.K. Kaul, Justices Sanjeev Khanna, A.S. Oka, Vikram Nath and J.K. Maheshwari, will commence with the hearing of the matter from 11th October this year. A constitution bench of the Supreme Court today stated that from 28th September, it will commence hearing of the matter where its indulgence is sought to consider the extent of its powers under Article 142 of the Constitution of India to dissolve a marriage. The 5-judge bench, headed by Justice S.K. Kaul and also comprising of Justices Sanjeev Khanna, A.S. Oka, Vikram Nath and J.K. Maheshwari, were of the opinion that the real issue is the exercise of power under Article 142 when there is an irretrievable breakdown of marriage but one party is not consenting to divorce. The Supreme Court today upheld the validity of the Haryana Sikh Gurdwara Management Act 2014 and dismissed the petitions challenging the constitutionality of the act. A bench comprising Justice Hemant Gupta and Justice Vikram Nath delivered the judgment in a writ petition filed in 2014 by a man named Harbhajan Singh, a member of the Shiromani Gurdwara Prabandhak Committee. The petitioner had challenged the Haryana legislation by arguing that the state legislature lacked the power to create a body for Gurdwara management, as such power was reserved only with the Parliament. A division bench of the Supreme Court of India has issued notice on a writ petition filed by the Association of Medical Consultants Mumbai, challenging the constitutionality of specific provisions of the National Commission for Indian System of Medicine Act 2020 as well as the National Commission for Homeopathy Act 2020 as well as the 2020 amendment to Regulation 10 Clause 9 of the Indian Medical General Council Postgraduate Ayurveda Education Regulation of 2016. These provisions, introduced in 2020, form the keystone of the centre's decision to integrate different kinds of alternative medical systems such as homeopathy and Ayurveda with modern or mainstream medicine, commonly known as the allopathy, by allowing practitioners of alternative medicine to hold office as surgeons and practice modern medicine and in certain cases be trained to perform a number of surgeries. In a plea pertaining to the OBC reservation in the upcoming municipal body polls in Bihar, the Supreme Court has allowed the parties to mention the matter before the Patna High Court, where it is pending adjudication for an early listing. A bench comprising Justices D.Y. Chandrachud and Hima Kohli also requested the Chief Justice to take up the petition at the earliest, precisely in the course of the present week. The Supreme Court of India has sought a status report from the Union Government regarding the appointment of ad hoc judges in High Courts under Article 224A of the Constitution of India. Article 224A enables a Chief Justice of a High Court with the previous consent of the President to request a former High Court judge to sit and act as a judge of the High Court to hear cases. The provision has been invoked very rarely in judicial history of India. In April last year, the Supreme Court, after taking note of the increase in vacancies in High Courts, had stressed on the need to appoint ad hoc judges and had issued a host of guidelines regarding the same. In a plea challenging the order of the Delhi High Court directing to hand over affairs of the Indian Olympic Association, that is the IOA, to a committee of administrators, the Supreme Court has asked the Union Ministry Youth Affairs and Sports to discuss with the Director of Olympic Solidarity and NOC Relations, International Olympic Committee, and revert to the Apex Court primarily on the issue of appointing a neutral person to run the day-to-day administration of the IOA. The matter will now be heard next on 22nd September. The Supreme Court of India has directed the State Legal Services Authorities to form a scheme for empanelment of paralegals in police station for dealing with POCSO offences using the Delhi State Legal Services Authority scheme as a model within 3 months. A bench of Justices Indira Banerjee and M.M. Sundaresh further directed that the respective state governments as well as the union government will be in charge for disbursing funds for the implementation of the schemes. The court was hearing a petition moved by an NGO named Bachpan Bachao Andolon seeking directions to concerned authorities to urgently implement the safeguards available in child protection legislations. The Bombay High Court has refused to direct BMC, that is the Bombay Municipal Corporation, to consider regularizing 300% additional construction at Union Minister Narayan Rane's Juhu residence. The High Court said that the corporation is bent upon considering the application for regularization irrespective of the provisions of law. However, allowing the petition would be encouragement of wholesome unauthorized constructions, the High Court said. The court was dealing with a second petition filed by the Kalka Real Estates Private Limited, a closely held family concern of Rane, seeking permission of the BMC to consider a second regularization application under Section 44 of the Maharashtra Region and Town Planning Act. Dealing with an estranged couple's case related to the custody of their children, the Madras High Court in an interesting order said that marriage is not for mere satisfying the carnal pleasure but mainly for the purpose of progeneration. Justice Krishnan Ramaswamy was dealing with a petition filed by a woman, lawyer by profession, for interim custody of her 2 minor sons from her husband, who was also a lawyer. Stating that though courts are mindful of the interest of the child, Justice Ramaswamy said that it is to be lamented that the law leaves the child with only one hand rather than two. The court also said that the child brought into this vicious world through the act of the two individuals for their pleasure is made to suffer for no fault of his. The Bombay High Court has reprimanded the District Collector Mumbai Suburban and the MCZMA over the demolition of an old crematorium in Mumbai without serving any notice to the local fisher folk who built it. The division bench of Chief Justice Dipankar Datta and Justice Madhav Jamdar saw red over the manner in which the authorities obtained demolition orders from a coordinate bench when the Chief Justice was unavailable. The bench noted that the fish folk were neither made party to the petition at the time of seeking demolition orders, nor were they put to notice despite the court explicitly stating that any demolition must be in accordance with the law. In connection with the appeal seeking restoration of alleged temples in Delhi's Qutub Minar complex, a Delhi court today dismissed an intervention application filed by one Kunwar Mahendra Dhwaj Prasad Singh seeking right over the territories running between the river Yamuna and Ganga from Agra to Meerut, Aligarh, Bulandshahr and Gurgaon. Additional District Judge Dinesh Kumar passed the order today. The matter has now been listed for hearing the appeals for October 19th. The ASI has contended that Singh claimed rights for large and vast areas in several states. However, he was sitting idle on it for the last 150 years without raising any issue before the court. Thank you. Keep watching Courts Today on Live Law for more such updates. See you tomorrow.